A very good evening to all the participants in this series of Know Your IP, the online weekly lecture series organized by the Office of DPIIT IPR Chair Professor, Osmania University, Hyderabad. Probably this is the 11th week of the lecture series, and we have covered number of issues in the previous sessions. Today, we have a very important topic, namely the IP waiver for COVID-19, the road ahead for global technology transfer. And to discuss this very important issue during the period of COVID, maybe even more relevant during the post-COVID era, which is expected to be nearby. We have with us Dr. Yogesh Pai, faculty, National Law University, Delhi. And at the outset, I thank him for accepting our request and to share his invaluable experience on this particular area with all the participants. It will be my pleasure to introduce Dr. Pai briefly because he has a lengthy introduction and many achievements. And in fact, I've had the fortune of meeting him for the first time, not in India, but on a foreign soil, probably in Malaysia, when myself, Dr. Sai Ramani Garimella, Dr. Yogesh Pai, all of us were participating in ASLI conference almost 7 to 8 years back. The formal introduction, which is condensed, is Dr. Yogesh Pai is an IPR specialist with special interest in the area of intellectual properties interface with competition, trade, and economic policy. And he is my counterpart, the DPIIT IPR Chair Professor in National Law University, Delhi, apart from being the co-director of the Center for Innovation, IPR and Competition, National Law University, Delhi. Dr. Pai has a very illustrious career as a teacher, researcher, and scholar. He was Thomas Edison Fellow 2017-18 at George Mason University, Washington, D.C., visiting scholar at School of Law, Washington University, a tutor with World Intellectual Property Organization's Academy of Distance Learning Program. He is on the editorial board of the WIPO WTO Teachers Colloquium annual research papers. And Dr. Pai is a well-known speaker on intellectual property issues, not only in India and also abroad. And Dr. Pai delivered papers on intellectual property and related issues in several international seminars, conferences in number of countries, including Singapore, Malaysia, United Kingdom, USA, Brazil, Switzerland, so on and so forth. And his series of publications is quite impressive. And he has published in almost all the peer-reviewed journals on areas relating to intellectual property rights. And Government of India has recognized the services of Dr. Pai and made him a member of several expert committees on IPR and related issues from time to time. And I'm very sure that our participants will be immensely benefited from the lecture delivered by Dr. Yogesh Pai on this particular topic, namely IP waiver for COVID-19, the road ahead for global technology transfer. Just one sentence on this particular area because I had an occasion to listen to and read about his excellent lecture delivered in another, in fact, state, adjacent state, organized by, DPIIT chair on a related issue. And this is the issue which has number of complex questions and key solutions, and public health issues versus the private rights protection, this is an ongoing, in fact, discussion which has been going on for several, decades. And there are number of issues where some of the Western countries also, in fact, upheld the authorization of compulsory license on public health. The question is whether IP waiver is the solution, or there are any flexibilities within the TRIPS agreement and the national regimes. I don't want to make any forays into the terrain of Dr. Yogesh Pai. I proudly present Dr. Yogesh Pai for all the participants. Over to you, Dr. Pai. Welcome to DPIIT, IPR Chair, Osmania University. Thank you.
Thank you, Professor Reddy, and it's extremely, it's a great honor to be amongst all of you, and good evening to all of you. The main arguments in relation to intellectual property waiver are brought forth with. Now, I think there is a background to all this that we all need to, sort of understand in the context of intellectual property, vaccines, and COVID-19 drugs and diagnostics. So now, one of the major ways in which private sector innovates is through intellectual property. The reason being that the incentives argument is very, very strong in relation to private capital, because private capital is invested based on what is called as opportunity cost, which means 100 rupee invested in your FD account is different from 100 rupee invested in your shares, vis-a-vis 100 rupees invested in one form of R&D in, say, telecommunication sector, with vis-a-vis 100 rupees invested in the pharmaceutical sector. And each of these, carries a different opportunity cost, primarily because of the nature of risk in the particular industry. And historically, if you see through the evolution of the patent system particularly, patents are considered as one of the most important instruments as far as the pharmaceutical industry is concerned, and also in today's context of biopharmaceuticals, etc., including diagnostics and drugs and vaccines. Now, in this background, it is very clear that what intellectual property as a legal instrument does is to allow you to exclude others from copying your inventions, right? Patents primarily do the job of protecting your inventions. Copyright primarily does the job of protecting you against copying of your works, such as literary works, particularly in the context of your literature, or in case of music, films, etc. There is copyright that is provided, including in relation to software. The copyright protection extends to both source code and the object code. Similarly, industrial designs protect the external ornamental aspects of any of your product, particularly in relation to diagnostics. There is a greater element of industrial designs, etc., involved in relation to building of a finalized product. And similarly, there are trade secrets involved in any of the what you call COVID-19 drugs or vaccines or diagnostics. It depends on the nature of the product as to what extent there is a secrecy element involved in the product and what might have been patented. But definitely at various levels, depending on the complexity of the drug, etc., there would be some amount of trade secret involved. So these primarily modes of what you call intellectual property protection in relation to a product and a health product means that it gives a kind of an exclusivity for a limited period of time to the owner of the intellectual property, whoever owns it. So intellectual property is a dominant mode of commercializing inventions also, primarily because even if, say, the public sector or the public sector labs invent any kind of molecule, drug, or any other kind of health related invention, to take the invention from the lab stage to the market is a task that the private sector is cut out to do. In that situation, it would be very important that some form of intellectual property protection is made available to including those who invent in the public sector and in the universities and in research institutions. Because if the private sector wants it to take it from the lab stage to the market, commercialization and incentives for commercialization through intellectual property protection is one of the key arguments as to why even patents are important in public universities and research, right? So in this background, it's very clear to us that intellectual property is a kind of a dominant mode of innovation and commercialization of research, particularly in the context of health related products. Now, having said that, one of the key economic effects of intellectual property is that when you have the right to exclude others from making, using, selling your own invention, or offering for sale, or doing importing, including importing your inventions, it means that to that extent, the exclusive control over how much to produce or how many quantities of a particular drug to produce is left with the owner. And why is it left with the owner? Because in a normal market situation, in a very competitive market where there is no IP, which is difficult to imagine because some form of IP is necessary from a competitive perspective also. The reason being, if you just engage in price competition or just in output, then what you will end up is producing the same products and not new products. And if you want to have competitiveness in that innovation space, then some form of intellectual property is considered as necessary even from a competition perspective. Now, in this context, what happens is, because intellectual property provides this exclusionary right, the amount of output that is there in the market does not face any external competitive entry for that limited period of time. In India, for example, the patent is protected for 20 years, right? So in such a situation, then ultimately the exclusivist tends to become an economic monopolist also, depending on how closer the existing substitutes are and how far is the new entry that is going to displace the existing exclusivist or a monopolist. So in such a situation, particularly the exclusivity nature of intellectual property means that if the owner has the power to decide how many units to sell, and why is that power important for the owner of intellectual property? Because if he produces large number of products of a particular invention, at the end of the day, if he or she has to sell them in the market, then the more the supply in the market from his own side, in spite of him being an exclusivist, the lesser and lesser the price that he should make it available in the market, right? Because if you're catering to a higher supply, then the prices are going to be lower and lower. In a situation where there is competitive entry, competitors lower the prices by competing with the existing market players. Here, you are then allowed to have that exclusive control in the market by limiting supply. So once you say limiting supply, it becomes a problem in the context of health, right? Why so? Because naturally, health is one commodity wherein it affects all of us, and naturally, with various paying capacities, everybody is not then able to access particular drugs, vaccines, or diagnostics, or whatever the kind of health product that be. So this innovation access, kind of gap is one of the major, issues that goes into the crux of the economic aspects of intellectual property. Because the reason, that is often cited for granting intellectual property protection is incentives for creating of new products. But at the same time, when these new products don't become accessible, and if there are no closer substitutes available, and fresh entry from other market players to displace the monopolist is significantly far away, then during that period of time, the society suffers in terms of lack of adequate access to these particular health products. So keeping this in background, we'll move on to what happened during the COVID-19 pandemic. Now, we have accepted a regime on intellectual property rights within the framework of the World Trading Organization. This is an international regime wherein the World Trade Organization, which is established through what is called as a Marrakesh Agreement on Establishment of the World Trade Organization. Under that, there are 3 or 4 main texts or agreements. One is the GATT, that is General Agreement on Trade and Tariffs, which relates to goods. Then you have GATS that relates to services, and TRIPS that relates to intellectual property. And all 3, including the Marrakesh Agreement establishing the World Trade Organization, is linked to what is called as a dispute settlement understanding, which means If any of the countries who are members of the WTO violate these agreements, then within the context of the World Trade Organization, there is a panel and there is an appellate body which can decide on the fact of whether a particular violation has occurred due to a member country's domestic law or domestic measure. So in that sense, if any of these agreements are violated, any other party of the WTO can take the other member to the dispute settlement and can resolve their disputes. And in terms of remedies available for countries that violate, countries that win the cases at the WTO, there is a suspension of measures that is possible by allowing those countries who win the cases to take action against the other party if the other party does not bring the measure into compliance within a reasonable period of time. And bringing the measure into compliance means the laws that were WTO incompatible have to be made WTO compatible based on the recommendation of the panel or the appellate body at the dispute settlement understanding. Now, if they don't do it, if countries who lose the case don't bring in compliance the law, then the winning countries are given the permission by the WTO to exercise suspension of measures, concessions, which means basically if two countries are importers and exporters, then one of the countries who has won the case and importing a particular what you call product from your country which has lost the case, then the winning country can impose higher tariffs, which means that makes your product, the exporting country's product into the importing country expensive, and consumers may not prefer your products because higher tariffs means the product becomes expensive in the domestic market. And that's how the WTO provides the country which wins the case to exercise a deterrent kind of effect on the losing party. Now with this structure in mind, the trade related aspects of intellectual property rights agreement was negotiated between 1986 and 1994 during what is called as the Uruguay round. Prior to the Uruguay round, intellectual property was not a kind of issue that was regularly discussed in the trade context. The right forum to discuss intellectual property and to negotiate treaties on intellectual property has always been the World Intellectual Property Organization and its predecessor. So since 1883, you have the Paris Convention, and 1886 you have the Berne Convention, which largely are the two substantive treaties which were there in force for around 100 years. And after 100 years, and this was at the WIPO, and after 100 years, when countries realized that further reforms within that forum were not possible because developing countries were opposing any kind of further strengthening of the intellectual property at the WIPO, and WIPO did not have a mechanism such as dispute settlement. That's the reason developed countries took intellectual property at the trade forum, and within the context of the formation of the WTO, a treaty was negotiated by linking this intellectual property standards to the dispute settlement mechanism. Now, what were the standards in the TRIPS agreement? Primarily, what the TRIPS agreement does is, it, in relation to, for example, patents, copyrights, industrial designs, and including trade secrets, it carries forward some of the aspects of the Paris Convention and the Berne Convention. So the substantive provisions in the Paris and the Berne Convention, which were negotiated since 1886 with 5 revisions in mind until 1970s, are now part of the TRIPS agreement. Plus, the TRIPS agreement also has certain additional provisions in relation to patent protection, copyright protection, industrial design protection, plant variety protection, semiconductor chip protection, trade secrets, etc. Now, which are 7 categories of intellectual property identified in the TRIPS agreement. Now, in relation to patents, what did specifically the TRIPS agreement do? It said that members, whoever are the WTO members, will not discriminate between fields of technology, which means basically you can't say that you are not going to grant pharmaceutical patents, right? You can't say you are only going to grant mechanical patents. Secondly, it also said you can't discriminate based on product and process patents, which means basically both product patents and process patents have to be granted in all fields of technology without discrimination. Discrimination as to the field of technology, discrimination as to the place of invention. For example, WTO members can't say we don't want to grant patents because these inventions were invented in some other country. No, that cannot be done. So WTO members have to grant patent protection in a non-discriminatory manner, and to all kinds of technologies. And what was the major argument at that point of time? Countries like India had benefited by not being part of any international treaty by that time, including the Paris Convention. So what we had done was we had a system in place where we had suspended any kind of patent protection for pharmaceutical, agrochemical products and food substances from 1970 onwards. And during the signing of the TRIPS agreement, this point became a rallying point for pharmaceutical companies to impress upon their government to negotiate a strong protection for both products and processes in all fields of technology, including pharmaceuticals, which means India then had to amend her laws. And by 2005, we amended the laws and we bought a product patent regime. Although the TRIPS agreement was negotiated in 1995, it allowed a 10-year transition period for those countries who, at the date of signing of the TRIPS agreement, did not have a product patent regime for pharmaceuticals, agrochemicals, etc. So they said you can take 10 years transition period and you can bring in the product patent regime. So India did that. So India is now a TRIPS compliant country. Having said that, once you grant these kind of limited monopolies, there is also a threat that during emergencies or even non-emergencies where there is a serious access related issue because of the higher pricing that is possibly with reference to any kind of patented drug, countries argued, particularly led by India, that if you are granting patent protection, also allow us the set of flexibilities to grant compulsory licenses, etc. So a specific article in the TRIPS agreement laid down the conditions under which you can grant compulsory licenses. It does not specify the grounds on which you can grant compulsory licenses, but the conditions. Now, one of the important condition is that there has to be compensation. So you cannot, take away somebody's property right by, granting a compulsory license and allowing competitive entry and not grant any compensation to the owner of the intellectual property, that is owner of the patent. The TRIPS agreement requires what is called as adequate remuneration. How do you decide on the adequate remuneration? Is left to your individual domestic law. Similarly, there are other conditions attached in the TRIPS agreement while granting these compulsory licenses. And what do we essentially mean by compulsory licenses? Basically, if the owner of patent refuses to license, then any person who wants to manufacture the particular patented product, which is a reflection of a patented invention in India, then that particular firm, which is largely essentially a generic firm, can go to the Controller General of Patents and apply for a compulsory licenses. In India, there are three grounds that are recognized. One is higher prices. Second is that the reasonable requirements of the public have not been met, which means basically there is a huge unmet demand. And third is that it has not been territorially worked, which means basically in some way or the other, the particular patented invention has not been essentially manufactured in India. Of course, there are contestations with reference to how you understand working, in the sense of whether it should be manufactured or is it just enough whether the patent holder licenses it and does not engage in any manufacturing, or will that be considered as effectively manufacturing by the patent holder, etc. are nitty-gritties of the issue. But broadly, it allows for compulsory licenses. Apart from compulsory licenses, TRIPS agreement also allows for government use for, if in case the government wants to use it for its own purposes, or it can also direct the third parties to, use the particular invention. The TRIPS agreement allows such use without authorization, provided there is a system of compensation. And apart from this, if there is a small limited exception that has been created, say for example, for the purposes of research, most as far as scientists are concerned, they would always be concerned that while researching in their labs, they should not be hauled off for any patent infringement, right? So the law gives them an exception, and the TRIPS agreement recognizes that there could be such limited exceptions which do not conflict with the normal exploitation of the rights of the right holder. And in countries like India, what have we done? We have said that a research exemption is such a limited exemption. And when we say it's a limited exemption, which means basically it is limited in nature because it is only for the purposes of research. If you want to commercialize the invention further, then you need to take a license. And of course, if a license is not granted, then you can again go to the controller and complain that a license is not received, and then upstream patent is blocking you from commercializing your invention, and then the compulsory licenses can be issued under the Indian law even for those purposes. But the small research exemption helps scientists, for example, to conduct research without the fear of patent infringement. Okay. Now, all these exceptions were there in the TRIPS agreement. But during COVID-19, what essentially happened was that COVID-19 vaccines are biological products. They are in some way complex biologics, right? So in regards to chemically synthesized inventions, okay, there is not a lot of trade secret that is involved in a product, right? And that's why in chemically synthesized invention, once the chemical formula is known either through the disclosure in the patent application or through reverse engineering, then anybody in the market can actually make such a particular important chemically synthesized invention. That's not true of vaccines. In case of vaccines, there is a technical impediment to replicate the vaccines because these are complex biologics, and in many cases, a certain amount of vaccine technology, particularly the know-how elements, and in relation to the material, base material, etc., are not disclosed in any patent application, nor are they available to you unless you try and invent it yourself. Which means basically, at the end of the day, trade secrets are one of the most important barriers in relation to vaccine production. So even if a patent is filed or not filed, it may not matter so much as far as vaccines are concerned, because to produce vaccines, you also need to know the know-how. And it is in that context, this whole debate arose with reference to how would developing countries now be able to access vaccines. Why? Why so? Because if vaccine inventions are largely in the European world and in the northern countries, that is the northern hemisphere, USA, Canada, and Europe, Japan, etc., what happens to the developing countries and the low and middle income countries and the LDCs? As far as LDCs are concerned, there is already a waiver that has been granted since the establishment of the TRIPS agreement. LDCs do not have to implement LDCs are least developed countries. They do not have to implement any of the provisions of the TRIPS agreement, or in relation to pharmaceutical patents, they do not have to grant pharmaceutical product patents until 2033, which means basically there is a huge waiver already present for as far as LDCs are concerned. Then for whom was this concern? Major concern was for developing countries who had the manufacturing capacity but did not know how to manufacture those vaccines. So countries like India at that point of time said, if intellectual property is going to become a barrier for us to sort of manufacture vaccines, maybe we should suspend intellectual property for a certain amount of time. But if you want to domestically suspend intellectual property, then you would be in violation of the TRIPS agreement. And how to do it will be a big question, because you may be taken to the dispute settlement body for suspending TRIPS obligations as far as your country is concerned. Because the TRIPS agreement requires you to grant patents. TRIPS agreement requires you to grant patents for 20 years. TRIPS agreement requires you to grant patents for all fields of technology, which means including vaccine technology. There are very few subject matter exceptions in the TRIPS agreement, and definitely it does not say that vaccines can be excluded. So as far as TRIPS is concerned, vaccine technology is also then, particularly vaccine products, then become patentable. And as far as TRIPS agreement is concerned, trade secrets in relation to any product, if they are exclusively in the possession of a firm, are to be protected under Article 39 of the TRIPS agreement. And WTO members shall protect such trade secrets against misappropriation. And as the way in which trade secrets function is that trade secrets are not registered somewhere. They are not disclosed somewhere. They are considered as valuable because they are in secrecy and they are held in the exclusive possession of the firm. So the countries who want to then force the firms to disclose trade secrets must have a law to and possibly a draconian law to push the firms to disclose their trade secrets. And that the TRIPS agreement does not allow, because TRIPS agreement under Article 39 clearly says that WTO members shall protect such trade secrets. Unlike, for example, compulsory licenses of patents, there is no compulsory licensing for trade secrets. The reason being, because trade secrets are not a positive form of property protection granted by the state. What the state does is that it recognizes your secrecy as long as you keep it in secret. But the moment somebody misappropriates it through espionage or through poaching your employees, etc., then if the party who owns the trade secret approaches a court, then the court has to grant a remedy for a breach of contract or for breach of confidence. So that's the limited kind of enforcement that the state does with reference to trade secret. Unlike patents, for example, where the state provides positive form of property protection through the system of exclusive rights, right? So in that sense, trade secrets are not treated as generally as property. They are treated more so as a form of unfair competition, wherein if you possess trade secret and if somebody takes it from you, unfairly, then the law will come to a help. The court usually will grant a remedy in your favor, prohibiting the other person from, continuing further with the misappropriation of your trade secret, and also making them liable to pay you damages. So this is the reason countries like India and South Africa argued that countries must be allowed to suspend intellectual property protection in relation to COVID-19. So what are the forms of intellectual property protection in relation to COVID-19 health products? Majorly patents, trade secrets, industrial designs, particularly in relation to diagnostic products, etc. And also to some extent copyright, for example, in relation to software, health-related software, etc., which may be used for delivery of vaccines, etc. If those copyright on software is becoming an impediment, then naturally what was being argued is that such copyright should also be allowed to be suspended. And if you want to suspend intellectual property, you have to make a request to the World Trading Organization under Article 9 of the Marrakesh Agreement establishing the World Trade Organization. And under Article 9, there is a provision where WTO members can propose, and through a method of consensus or through a 3/4 majority, a waiver can be passed. So as I mentioned to you, there are already existing waivers as far as LDCs are concerned, right? And how are these waivers passed? Through a similar measure, wherein 3/4 of the WTO members agreed that LDC members of the WTO need not implement the TRIPS agreement. And this waiver has been happening since the establishment of the TRIPS agreement, right? So LDCs are already under the waiver. As far as COVID-19 is concerned, developing countries said this waiver must be now allowed to be used by any country who wants to suspend domestically their IP rights. Now, India and South Africa's joint proposal received support from around 2/3 of the members. Okay, and within a period of 3 to 6 months, 2/3 of the members agreed. But as I mentioned to you, the membership that is required, is either through a consensus or through at least 3/4. And if you want to get 3/4, then the major bloc that has to agree to this is the European Union. So European Union opposed the waiver. United States of America initially opposed the waiver, and Canada, New Zealand, many other countries, UK also opposed the waiver. And this waiver proposal made in 2020, until say, for example, the second wave, that is March and April, particularly April 2021, was lying in dormancy, very slow discussions at snail's pace. But when the second wave happened, there was suddenly a discussion again, re-emerging on the waiver. At that point of time, US conceded that they will negotiate certain aspects on the waiver. Many other countries are still saying they don't want to negotiate. For example, European Union, UK, etc. US said we will negotiate a limited waiver for patents, basically saying that patents and vaccines. So basically saying that whoever wants to sort of suspend vaccine-related patents, we will try and negotiate a waiver for vaccines. Now, this discussion has been going on ever since then, and the next meeting of the TRIPS Council is going to be held in March, where again this issue is going to come up, and nothing has been decided until now. European Union said they will make a counter proposal to the waiver, and they said that in that counter proposal they will allow more flexibilities to use what you call patents and compulsory licenses in relation to patents and allow their exports in a much faster way. That is what the European Union proposed. However, this is not acceptable to the countries which have proposed the waiver. Now, what is one of the major issues in relation to vaccine production? If you look at the scenario in India today, ever since the COVID-19 pandemic broke out in February and March of 2020, 2019 was initially the first cases, but in India, for example, since March 2020, we have had lockdowns, etc. Ever since then, countries, manufacturing firms, private companies, both in India, Europe, elsewhere, have used their innovative capacities to come up with vaccines. In fact, if you look into vaccine research, usually it takes a period of 8 to 10 years to come out with a fully developed vaccine product. And here we can see that vaccines were available, at least based on emergency use authorization, in a period of say 12 months max, because COVID-19, since November and December and January, you had these vaccines approved, of course, based on emergency use. And by now, many have also submitted for the full use, and they have gotten the approval. But even then, it is the shortest period of time within which many companies have been able to come out with vaccines. Previously, you can see that it took 5 years, 8 years, 10 years to come out with vaccines by passing through the regulatory structures. Here, they were granted emergency use and they have proved effective. And there are around 10 different vaccines that are already, available, out of which most of them have been licensed to companies in India. And this licensing has happened, voluntary licensing has happened since the ongoing, start of the pandemic. For example, there were deals struck between Serum Institute and AstraZeneca. AstraZeneca and Oxford University, they collaborated to come out with the vaccine, right? And that technology has been licensed to Serum Institute of India, which is one of the largest producers of vaccines in the world. Similarly, Novavax and Serum Institute struck a deal. Of course, Novavax product didn't come until recently, but it was one of the early deals struck by Serum Institute with another company, foreign company called Novavax. Biologically, for example, also struck a deal with deal for Corbevax vaccine with Baylor Institute of Medicine, Texas. Right? They came up with this vaccine, and interestingly, this vaccine is based on an open license, wherein they are not even charging royalties for any kind of technology transfer. Sputnik from Gamaleya Institute, Russia, was the technology transfer has been done to many firms in India, including Dr. Reddy's, etc. Right? So you have various cases. Bharat Biotech, for example, India's own indigenous vaccine, which was developed with the support of ICMR in India. You have various vaccines wherein the technology has been transferred by foreign companies into India, except the mRNA technologies. Now, mRNA vaccines, there are two major mRNA vaccines right now which have been approved in the world. One is by Pfizer and the other one is by Moderna. And both of them have refused to license it to technological partners in India on a full technological transfer basis. And this was also primarily because, because CCMB tried, Center for Molecular Biology based in Hyderabad, they tried to, get the technology transfer deal agreement with Moderna, and it did not happen at that point of time. Subsequently, what happened was Indian government itself took a decision not to import those medicines. And Cipla, for example, was in talks with Moderna to strike a deal to do it on fill and finish basis, not on a full technological transfer basis, but where the medicine would come here, you would fill and finish it, and sell it in the country. Now, what is the major problem? The major problem is that mRNA is a very new platform which has multiple uses. That's why these companies do not want to license it widely when compared to other platforms like, for example, AstraZeneca or other kinds of protein subunit vaccines like Corbevax, etc. Primarily because the value of this platform remains unexplored. And both Moderna and Pfizer thought if they are the pioneers in this particular technology, why should they just transfer the technology to other companies and there will be higher spillovers? And if there are spillovers, then the full potential of this platform they will not be able to achieve. And in case of these mRNA technologies, the major impediment is not only in replicating the technology independently, but also getting its regulatory approvals. And both Moderna and Pfizer knows that a large part of this mRNA vaccine technology are know-how and processes and trade secrets, and also the kind of regulatory dossiers that they need to submit to the regulators with reference to safety and efficacy of the vaccine. So that is one of the reasons why many countries who wanted access to such technologies did not have any access, because Moderna and Pfizer wanted to limit their what you call licensing activities across the world. In fact, they have not licensed it widely, and they have just produced it in Switzerland, in Canada, and in the United States. So that's why countries like India were now thinking that waiver would help them to actually get access to the technology. But is it so is a big question. The reason being, what do you mean by a waiver in the WTO? A waiver within the WTO means basically countries can domestically suspend their intellectual property obligations that are there in the TRIPS agreement as far as COVID-19 diagnostic drugs and vaccines are concerned. But these people who own the technologies, these companies are residing abroad. Pfizer has its what you call activities in India. Moderna does not. But even if you were to force these companies under a waiver, and even if you want to say that a company like Pfizer has to be forced, Pfizer would simply withdraw from the Indian market. Moderna is anyway not there in the Indian market. So to that extent, what would essentially happen is basically you would end up in a situation wherein your domestic withdrawal of your IP laws will not force the American companies to do a tech transfer, because the laws of America govern those countries, which means basically US will have to force those companies to do a technology transfer with Indian companies, and waiver cannot achieve that. Waiver cannot achieve that. What can the waiver then achieve? Waiver can possibly allow you to suspend trade secret protection, but suspending trade secret protections means nothing. You will have to then bring in a law wherein you force those companies, for example, the Serum Institute, etc., to disclose their trade secrets to 10 other companies or 20 other companies based on who wants to produce those vaccines. But the government of India already knows that Serum Institute is at its full capacity, and others, have vaccines have been already licensed, some on open licensing basis. So essentially, then it's not a domestic issue that needs to be addressed. It's an issue wherein we want access to foreign technologies wherein the companies are located abroad, and unless their governments force them to do a tech transfer with Indian companies, the waiver cannot naturally, logically help us to achieve what we want to achieve in terms of access to mRNA technologies. Having said that, in spite of the waiver, even without the waiver, if countries want to reverse engineer or independently innovate and come out with what you call mRNA vaccines, they are free to do so, right? And this has largely happened in case of Genoa Pharmaceuticals in Pune. They are trying to reverse engineer and they are trying to independently come out with their own vaccine, mRNA vaccine. Similarly, the tech transfer hub that was established by the World Health Organization in South Africa, there the World Health Organization had a pool of scientists who are microbiologists to help this company called Afrigen to successfully replicate Moderna's mRNA vaccine, independently develop it, in fact, and they were successful. The only thing is, to get that vaccine to the market requires them to go through regulatory trials, which they are currently doing. And maybe we can have the vaccine, mRNA vaccine, by the end of this year. At least that is what is the expectation, or maybe early next year. But it will have to go through its own independent regulatory trials, because Moderna and Pfizer have refused to share the technology and have refused to share the regulatory data with the WHO or with other companies who want to come out with their own independent mRNA vaccines. Now, however, unfortunately, the waiver doesn't do that, because the waiver simply means that you are allowed to suspend your own domestic law. If you suspend domestic law and if you suspend trade secrets, and if you want to do forced technology transfer, you can only do it against companies which are located in your territory. How can you force American companies to do a tech transfer with India unless their governments do so? And it is highly unlikely, because in most of these countries, trade secrets, patents are protected as private property rights. In fact, in the US, it is a constitutional right also, right? So this is the complexity of vaccine scenario, wherein we need access to technologies which are located abroad, but the waiver will not provide a solution. Then what is the exact solution then? The exact solution is tech transfer. Tech transfer has voluntarily been done in many cases in India. You have examples of Serum Institute, which has license for Novavax's vaccine, and which has license also for AstraZeneca. You have Biologically company which has license for Corbevax. You have other companies, 7 other companies which are producing Sputnik. You have Bharat Biotech, which is already producing its own indigenous vaccine. So the only vaccines that have currently not been licensed in India, there is no interest in the Chinese vaccine Sinovac, but the only major vaccine that has not been licensed in India is basically Moderna's and Pfizer's vaccine. And to some extent, the Indian government itself has said that they don't want to import those vaccines. In fact, CIPLA asked the Indian government for a commitment from the Indian government that they are not going to impose price control, that they are not going to impose any custom duties, they are not going to impose any indemnification, they are not going to impose any bridge trials, etc. as far as their possible deal with Moderna is concerned, but the government of India did not agree. So what we then essentially did was we relied on the existing technology platforms that are available, and mostly the widely used vaccine platform has been AstraZeneca's and Oxford University's COVID Shield vaccine produced by the Serum Institute. So that's where we are. So problem then lies in what needs to be done in the future. If you want to get a technology transfer through international law, it will require a lot of negotiations. Why? Even if, say, United States and all developed countries agree to do technology transfer, the governments are not the owners of technology. Private parties are the owners of technology. Which means, even if in the TRIPS, suppose we agree for a technology transfer deal, which is not part of the waiver. Waiver only means countries can suspend their domestic IP rights. But if you go forward and have a positive obligation on states to do this kind of technology transfer, how would they impress on their companies to do this kind of tech transfer? Because ultimately it's a question of financing. And as I mentioned to you, because there is a huge opportunity cost in innovation, companies would simply say, why should we innovate it at the end of the day? Ultimately, if you're going to force us to do technology transfers to countries and firms which we don't want to go, because we are sure that we are not going to get any kind of revenues or return on investment. And that is the crux of the structural problem of tech transfer, global tech transfer, wherein waiver will not resolve it. Waiver only means that countries will be free to suspend their domestic IP law. And this structural inequity caused because of lack of tech transfer between foreign companies and companies located in your own territory would mean that voluntary tech transfers are the possible way to go. If countries want to force tech transfers, and if a deal is stuck in the WTO agreement that countries agree to force their companies to do so, there will be domestic consequences of those in those particular countries, because they are protected as property rights at the end of the day.
Thank you so much, sir.
Thank you very much, Dr. Irfan and Dr. Pai. I must, place on record our immense gratitude to you. Now I request Mr. Srinivas Rao to propose vote. Thanks.
Thank you, sir. Good evening, sir. Good evening, IPR Chair, Professor, the organizing team, and all the participants. I would like to take this privilege to host today's vote of thanks on behalf of DPIIT IPR Chair, OU, Hyderabad. First of all, I would like to thank you, sir, for accepting this invitation and helping our viewers and participants in aligning their theories and concepts. Pandemic has taught us many lessons, and we learned many vocabulary which are related to pandemic, including the world pandemic itself. And for a person outside the domain of IPR, most of the words got discovered during this time. In terms of IPR, compulsory license, waiver, and rights related to patents were few terms which were introduced to a person who was out of the IPR domain during this pandemic. So you have explained those terms here on this platform very lucidly with the real-time examples in fine-tune to the audience who are present here. Your explanation with examples are also very demonstrative and efficient enough to have an experience like virtual reality. So some information such as nasal spray, which you have explained, were eye-openers, sir, for everyone. So you have consolidated the topics like patents, trade secrets, technology transfers, waivers, treaties, role of WTO, and more. And your lecture was very informative, in fact, and it has laid down a road for the global technology transfer and the prospect of IPR, sir. We would also like to thank our participants who join us every week, which reflects their urge to gain knowledge, and also thank our YouTube viewers also. Currently, we have more than 200 subscribers who are supporting us. So we will meet with another interesting topic. Until the next episode, on behalf of DPIIT IPR Chair, OU, thank you, sir. Thank you, everyone. Thank you.
Thank you very much, and it was a pleasure to talk to all of you. Thank you very much. Namaste.